basically, the mission of the Pro Bono Partnership of Atlanta is listed there. The eligibility, go online to the website, have a lot of good information. This presentation is not specific legal advice to your organization or about specific legal questions that you're facing, but instead it's general advice on employee handbooks. If you have specific questions, contact the Pro Bono Partnership. They'll direct you to resources or connect you with an attorney who can help you. So we'll start out with whether your organization is required to have an employee handbook, and the answer is no. There's no legal requirement for you to have an employee handbook. We would rather you have no handbook at all than a poorly drafted handbook or a handbook that you've downloaded online that has misinformation, outdated information, because that can cause many more problems for your organization than it helps to solve. So why should your organization have a handbook at all? A handbook helps to explain your company, your organization's philosophies to the organization as a whole, to set standards for the organization, to communicate your expectations to your employees, and to provide uniformity. What it also does, it helps provide defenses should your organization get involved in litigation, particularly employment litigation. But some of the problems that we see here is if you have a handbook, the problems that it can create if it is poorly drafted is not only can it violate laws on its face, but it can increase liability for you and your organization if you fail to follow the procedures that you've put in that handbook. And we'll go into some of those policies in more detail. So as far as the content of a handbook, one thing to remember is you can't include everything in an employee handbook. You can't include every detail on how your organization runs, on what is permitted, what is prohibited. So you can't include everything. What should you include? And I think it's important to remember that particularly for smaller nonprofits and even large nonprofits and large companies, there's no need to have an extremely thick handbook. I've seen handbooks that run on for hundreds of pages, and while that may be important for some large organizations that are global in scope, that really need uniformity and detailed direction worldwide, the larger that handbook is, the less likely it is that the employees are going to read it, and that the managers and people who are in a position to enforce what's in the handbook actually know what's in there and enforce it, much less to keep it updated. So it doesn't need to be thick. It doesn't need to include everything. What should it include? This is a list of items that we think are helpful to have in an employee handbook, and we'll go through some of these in today's presentation. A positive and personal introduction, an EEO policy, policies against harassment and retaliation, an at-will disclaimer, an introductory period, some notes on employee classification, the FMLA if you're a covered organization, a policy against recording, policy against unionization, and something that touches on the hot topic now of social media. So the big one to begin with, an EEO policy. Most handbooks have this, and they should. It's something that employees expect. It's something that the courts expect if they see one in front of them. Simply having one doesn't mean that your organization is going to win a discrimination case, but if you don't have it in there, that could help you lose the case, because we would rather, as our Exhibit 1 before the court, have a well-drafted EEO policy that we can say that the employee has seen, read, and the company has followed. What plaintiffs' bar would like to have as Exhibit number 1 is the lack of an EEO policy or an EEO policy that is incorrectly drafted. And so this is an important one. Some of the highlights to focus on, we're going to list all of the protected categories that apply to you federally, locally. Keep in mind that it applies to more than just discipline and termination, which is what most people think of when they've been discriminated against just with a termination. It applies to recruiting, hiring, advancement, promotions, demotions, things like that. We want to be able to point out that the employees are encouraged to notify HR without the fear of being retaliated against, which we'll talk about more later. The complaints will be kept as confidential as possible. This is a note that you'll see throughout the presentation is the lack of ensuring or promising complete confidentiality, because that may not be possible at all times. So just as confidential as possible. And the big part here is that the company will investigate. That's the key to the affirmative defense if your your organization is involved in litigation is that once the company found out about the discrimination, that it investigated and it took action that it found to be necessary. So again, avoid the promises about keeping confidentiality, and also avoid promising to give the results of the investigation. That's not something that's necessary. You don't always want to divulge those results to the employees. Another overarching issue with employee handbooks to keep in mind is that they essentially give promises to your employees that they don't already have. So we start with a blank slate here in Georgia that the employees are entitled to what they're entitled to under state and federal law and nothing else until you put it in an employee handbook. And once you start putting guarantees and promises into employee handbooks, then they become something that the employees are entitled to. So when you start making promises that you will do X, you will do Y, those are things that can bind your organization and can cause problems in litigation later on. So following up EEO policy, we should also have policies against harassment. Harassment can take the form of words, actions, or visual representations. I like to keep it simple in the employee handbook. I've seen many organizations try to list examples of harassment. They go on for pages. You're never going to be able to list all the examples. People tend to know what harassment is. Putting it in a more general, broad form will help to cover all those bases. Keep in mind this applies to all company personnel, but also your vendors, your customers, your clients. In fact, I saw a report this morning that involved the restaurant industry and said that 90% of females working in restaurants had experienced some type of sexual harassment from the restaurant customers at some point during their career. And that's important to keep in mind, that the company, the restaurant in that situation, but for you it would be liability for the clients that you're serving. You can potentially face liability if your clients and customers are also harassing your employees. You are notified and you fail to act on that. So it's not just about employees. Again, want to be able to report to the supervisor or to HR without the fear of harassment or retaliation. The company, again, will investigate and will keep as confidential as possible. What not to say in your anti-harassment policy is next. Avoid the phrase "report it to anyone." And the reason we like to take that out is because the last thing you want is for the employee who's being harassed to feel like they have to report it to the person who is harassing them, or they report it to a low-level manager who binds the company but doesn't yet have the training to know what to do with a harassment complaint. So you don't want to make it as broad as tell someone. You want to have a narrow class of representatives for your organization who are trained on what to do and how to respond if they receive a harassment complaint. So a good way to do this, if you have a director of HR, if you have the executive director, maybe open it up to some of the board members who hold appropriate roles. So limit it to a few well-trained people that gives the employee options so they can go multiple routes, but not so many routes to where they're encouraged not to take action whatsoever. The second one is report in good faith. Many that I've seen say that employees are protected if they report harassment in good faith. We encourage employers to take that out, because we've seen plaintiffs' attorneys argue that their client thought that he or she would be fired if the employer didn't believe him. So the good faith, they argue, is they didn't think they were going to be believed, and if they weren't believed, then they would be terminated, and so they didn't follow the company's policy in reporting it. Keep in mind that most companies, most organizations also have a separate policy against dishonesty. So if an employee brings a harassment complaint in bad faith and essentially makes up something about another employee, and the company determines that through an investigation, then the company can always discipline and terminate that employee through the dishonesty policy. There's no need to wrap the good faith aspect into an anti-harassment policy. We want to encourage employees to report, and so the employer can investigate and take action. That's the best way to have a defense in litigation. Next is a policy against retaliation. So we have a policy against harassment, and we're going to have a separate policy against retaliation. We like to do this because if an affirmative defense can apply for harassment, then we think that that same affirmative defense can apply for retaliation. And so the basis of that is that if the employee feels like he or she has been retaliated against, you encourage them to come to the company, come to their supervisor, come to HR, come to the director, and the company will investigate that and discipline the person who has violated that policy as necessary. One more word about retaliation is the reason we have a separate retaliation policy is these tend to be the most problematic cases for employers. It's quite often where an employee brings a claim not only for the initial discrimination or harassment, but also a separate retaliation claim because they say that once they complained of the discrimination or they complained about the harassment, the company retaliated against them. Those are much more difficult cases for the employer to win. It's not necessarily in human nature to discriminate or to harass, and so a jury can buy into the fact that the company took the action for legitimate non-discriminatory reasons. What's harder to sell is that the company or the organization didn't terminate the employee because they felt like they had been wronged during the initial discrimination or harassment complaint. If the employee had falsified the complaint or the investigation didn't turn up anything, then the employer would feel like they couldn't trust this employee and took action to punish them, in a sense, for raising that initial complaint. And so the retaliation part is key for handbooks, we believe. So those are the discrimination, harassment, retaliation issues. Now we'll get into some of the other aspects. The first one is the introductory period that we encourage employers to have in their handbook. And this slide walks through some of the aspects of that. How this works for most employers is a 90-day period during which the employer is evaluating the employee, and the employee is also encouraged to evaluate the company and make sure that that's a company or organization that they want to work with. What this is good for is at the end of the 90 days, you have a sit down, you have an evaluation with that employee to see if that person is going to be a good fit for that position, for that company, gives both parties the opportunity to part ways before getting too much further along into that relationship, because the employment relationship is just that. It's a relationship that, when it goes on for many years, becomes a very close relationship. And so we often liken this to a marriage. You are entering into a marriage, and this is your 90-day window to determine whether you regret walking down the aisle. And there are a lot of people that if they had 90 days during which to evaluate their marriage, we probably have a lot fewer divorces in this country. So think about that in the same way. If the employee hasn't sold you on the fact that they are the right person for the job at the end of 90 days, if there is any doubt in your mind at the end of those 90 days, chances are they're not going to remove that doubt as time goes by, because the employee should be putting their best foot forward. And if there's a hint that they're not, that needs to be addressed at the outset. And so that's why we implement this introductory period, is to give both parties an out early on. This shouldn't be confused with the notion that they have some sort of guaranteed employment at the end of this introductory period. That's definitely not the case. If you don't have an employment contract with the employee and you're here in Georgia, then it's going to be an at-will relationship. The introductory period doesn't change that. The person can still be fired at any time during the introductory period, and also once the introductory period is concluded. We found, however, that by using the introductory period, that employee knows that he or she is being tested and evaluated more closely during those first 90 days. And at the end of the 90 days, if the company does have a sit down and say, listen, this just isn't working out, then that reduces the likelihood that that employee is going to feel like he or she has been discriminated against during that termination, and instead knows that this was an introductory period, even if in name only, and that gives the employer a better chance of avoiding a lawsuit going forward, we've found. But again, it needs to be applied consistently to all employees. The introductory period doesn't need to be extended. We typically say 90 days. I wouldn't do it for more than 6 months. the only reason to extend an introductory period would maybe be for a leave of illness if that employee is out during that initial time. But otherwise, you don't want to say, we're not sure at the end of the first 90 days, we're going to put you on another 30-day probationary period. That to me sounds like you're already not sure whether the person is going to be a good fit, and so you need to make that decision early on. Problems are going to only get worse as time goes by, and that person is only going to have a stronger case that he or she builds if he or she remains at the employer. The next one is a policy against unionization. Not a huge concern yet here in Georgia for smaller nonprofits, I wouldn't think, but still something that we recommend be included. Just a simple policy saying that we are union free. We prefer to deal with our employees directly. If you have issues, we encourage you to come and talk to management. That is the best way of keeping positive employer relations, and will avoid the need for them to look elsewhere to a union to have that dialogue with their employer. Another small one that I would encourage you to implement is a policy against recording. I've had several employers call and ask whether they have to allow an employee to record a discussion with their manager about their performance. Many people are confused because they say that it is lawful to record, and they're often thinking of criminal law, because in several states it is legal to record a conversation that you're a party of. That doesn't mean that an employer cannot prohibit you from doing that at your place of employment, and in fact can discipline or terminate you if you violate that policy. So have a policy prohibits anyone from recording without express permission from the company while on company property. Next section on wage and hour. This is an issue that we could have a whole webinar on, that in fact Pro Bono Partnership likely does have a webinar on. I would encourage you to reach out to them to find more information on this, but it's the distinction between exempt and non-exempt workers, which is a big issue nowadays for nonprofits and for-profit companies alike. We like to have a short section in here that explains the difference between exempt and non-exempt employees. One glaring flaw that I see in most of the handbooks that I see, both for nonprofit corporations and for larger corporations, is this one here that involves overtime. And it says that if you work overtime without permission, that is unauthorized, you will not be paid for it, and you can be disciplined. That is a blatant violation of the Fair Labor Standards Act. The definition of employees to suffer or permit to work. And so if you permit the person to work, even without authorization, if they work for the company and provide a benefit to the company, they have been employed, and they have engaged in compensable work. So instead, what it should say is that employees are not permitted to work overtime without permission from their manager. But if they do, they will be paid, but are subject to discipline, including termination. So you are more than welcome to terminate, to discipline, but you must pay them for that time. That again is a flaw that I've seen in many handbooks, and it's an easy fix. So that's the FLSA. Very quickly again, that's a topic that you and your organization should spend a lot of time in looking at, both for volunteers, independent contractors, and your paid employees. So the next part, let's look at who is looking at these handbooks and what organizations are causing the issues for so many companies. And there are really two main antagonists. The first is the EEOC, the Equal Employment Opportunity Commission, or as businesses like to call them, everyone entitled to an occupation unconditionally, because that is how they seem to operate nowadays. The same with the NLRB, which is the National Labor Relations Board, or not liking or relating to business, especially under recent administrations. So we'll look at what these two organizations, what their separate issues are. And so first we have the EEOC. They are in charge of ensuring compliance with Title VII, which is all the race, sex, harassment, discrimination, the Age Discrimination Act, the Disability Act. So they cover non-discrimination, non-harassment, non-retaliation. So those are the issues that we talked about early on. The National Labor Relations Board is something that you're probably less familiar with and that a lot of companies are not very familiar with, and it's because it is in charge of enforcing the National Labor Relations Act. Again, an act that not a lot of employers have much experience with because it is seen as applying to union workforces. And while it is true that it has a lot to do with unions, it also applies to non-union workforces, and we'll talk about how it applies to you and your organization more. So we'll start off with the EEOC. First big one here are criminal history exclusions. If your handbook has a criminal background check policy, there is, I believe, another webinar that talks about background checks specifically. There's a lot of good resources out there that Pro Bono Partnership works with, so I'll cover it basically, briefly. The issue is that many companies have background checks, especially many Pro Bono Partnership clients, because they deal with at-risk youth, abused women, and so there are a lot of sensitivity issues involving background checks and ensuring that they don't hire someone with certain criminal histories in their past. Why the EEOC has been paying attention to this is because they've made the argument that certain blanket criminal history prohibitions are having a disparate impact on different protected classes. For example, if your organization prohibits felons from working, then you are going to just as a bright line test, rule out anyone who has a felony on his or her criminal history report, regardless of the time. The reason why that's problematic is the EEOC has found that it has a disparate impact on minorities. That's going to rule out many more minorities, and they have brought out guidelines about how to correctly have a criminal history exclusion. And the way to do that is to make sure that whatever exclusion you're interested in applies directly, has some sort of tie to your organization. There's a reason behind why you are having that exclusion. So rather than prohibiting felons across the board, which could cover anyone who was driving too fast to someone who has committed aggravated rape, that's a very broad spectrum, and that's not going to have a rational basis to an organization. Prohibiting felons as a general. But if your organization serves at-risk women or women who have been involved with domestic violence, then sure, it makes sense to prohibit felons who have engaged in some sort of aggravated domestic relationship, some sort of violence in their past, and you can exclude the violent offenders as opposed to other types of felonies. The other thing is to contemplate when the felony occurred. Was it something that's happened in the past 5 or 10 years, or was it something that happened when they were a teenager 40 years ago? The key here is not making too many bright line tests. It's looking at every applicant on an individual basis and to determine whether their specific criminal history is really a necessary bar to the position for which they're applying. Next onto the NLRB, and this has been in the news a lot lately because the NLRB, again, traditionally has dealt with unions and unionized workforces. As union membership has dropped to all-time lows, they have begun to find new relevance in non-union workplaces. And a big way that they have been doing that is through employee handbooks. The National Labor Relations Act, boiled down very simply, one of its most important parts is Section 7, which protects employees from engaging in protected, concerted activity that involves the terms and conditions of their employment. So if you think about unions, why unions exist, it's to work collectively through the union so they can bargain for better wages, better working conditions. That protection also exists to non-union workforces. If me and a colleague get together and start complaining that our law firm has terrible working hours, terrible pay conditions, we are protected by the National Labor Relations Act for having that concerted activity. And so what the NLRB has been doing is looking at handbooks to see how that is being chilled by some of the policies that are in the handbook. And so we will look at some examples of that as we move on. And so the first one here is confidentiality. The issue is that if there is a confidentiality provision in the handbook, that bars workers from discussing company, employee, or personal information, that can be interpreted as preventing them from discussing the terms and conditions of their employment, which we don't want to prevent. So confidentiality should not include things such as the employee's salary, benefits, working hours. So if you have a confidentiality provision, make sure that you carve out those areas, because we want to encourage employees to have the ability to discuss those items, because the NLRB has been saying that that simply having a confidentiality provision like that could prevent those employees from thinking they can lawfully discuss those issues with their colleagues, and so the board has been striking down policies such as this. There was a ruling that came down not too long ago from the board's Division of Advice that found that a blanket rule on confidentiality was too broad, but it did give some guidance on how the company could make it compliant. So I'll read what that is, and I'll highlight some of the key language here. So the employer may decide in some circumstances, that's very broad, may decide in some circumstances that in order to achieve these objectives, we must maintain the investigation and our role in it in strict confidence. If an employer reasonably imposes such a requirement and you don't maintain confidence, you may face discipline. So that's a very broad, doesn't lay down any sort of strict guidelines. It gives the employer a lot of flexibility to determine whether in that particular situation the individual has violated the confidentiality provision. So we don't just want to say that everything must be kept confidential that the employee does at work. The next issue is harassment. The board has been looking at this because we want to make sure that the harassment provisions are enforced consistently across the board. And so we have a little sample, some sample language here. The harassment policy does not prevent you from discussing the terms and conditions of your employment with your coworkers or discussing issues related to union organization in the workplace, provided that such discussions occur consistent with our non-solicitation policy. And that is the next slide, the non-solicitation policy. This is often included in employee handbooks, preventing people from distributing flyers of any type at work. And while it is okay to have a prohibition of distribution during work time and in work areas, so for example, you can't prohibit the distribution of materials during break times, meal times, break rooms, or parking lots. You can prohibit work time and work areas. The importance here is that it must be enforced consistently. So if you have a blanket prohibition, no one can bring in any outside materials to distribute at work, then that must be enforced consistently. Because if you have someone who is disciplined for distributing union materials, then you better be ready to discipline the employee who distributes Girl Scout sign-up forms for cookies or a March Madness poll. So you can't pick and choose what things are okay, and you can't prohibit religious distribution but allow things like Girl Scout cookies, because that's going to cause some problems with the board, because the board, if union activity starts to develop, then that could be chilled at work because of the non-solicitation policy. Next slide here, just again about what the board has been focusing on. They've been reading through these handbooks, trying to find a basis to overturn elections once unions try to organize at a company. So that is the reason why we want to pay so much attention to that. The next one here has been a popular one about social media and why the board is looking at social media issues. Recently, you may have seen where Facebook activity has been deemed to be protected activity. So if you have employees go on there and engage in a rant about a manager or about poor pay conditions, depending on the language that is used, could be protected activity. And if your social media policy has a blanket prohibition on that type of activity, then that's going to violate the NLRA and is going to be stricken down by the board. Most recently, a simple like by an employee on Facebook was deemed to be protected concerted activity, where an ex-employee had made a comment on her own wall that was negative about the company because they failed to take out enough taxes, and she had a great tax liability at the end of the year. Two current employees, one commented on the post and one liked the original post. Both of those employees still worked at the restaurant. They were terminated, filed a charge with the National Labor Relations Board, and it was recently upheld by the board that the terminations were unlawful because that activity, replying to the comment without any sort of disparaging comments and liking the initial comment, were protected activity because you have coworkers who are complaining about the terms and conditions of their employment. So be careful about blanket prohibitions on social media. The next page talks a little bit about some more items that you definitely want to prohibit in your social media policies. Prohibitions on sarcasm, criticism, those are all things that are going to be seen as chilling employee activity in discussing the terms and conditions of their employment. So the next slide is how we like to address social media policies. Is very simply, is that the rules that apply here in the workplace, regardless of social media, they also apply online and in social media. So our rules of conduct apply with equal force with respect to social media. While you're free to use social media in contact with your coworkers to discuss or otherwise address wages, hours, working conditions, and other terms and conditions of employment, your use of social media beyond those topics are governed by our policies to the extent they apply to off-duty conduct. So you can't harass while you're at work. You can't harass a coworker online. The same policies are in force. And if an employee comes to a manager and complains of that type of activity, you as the company have the same obligation to investigate and to discipline if necessary if you're going to avoid liability. All right, the next topic here, nearing the end, is a big one that is often included in employee handbooks, and that's a disclaimer that says that your employment here is at will. And I've seen this in a lot of handbooks. It's in bold at the outset, in a giant box saying, you are not entitled to work here. We can fire you at any time. While that is true, and there's nothing illegal about having that in there, here in Georgia, it's not really necessary because at-will employment is the law. Unless you decide to change it through an employment agreement, through an employment contract where you guarantee them some sort of rights beyond at-will employment, then that's the law. And so while it's important to have an at-will disclaimer that's in your handbook, there's no need to terrify the employees because you have to think that these employees are likely reading this at the outset of their employment. And so when they sit down at the beginning to read through the employee handbook so they can sign that they have read and received it, they're going to read some huge box saying that you're not entitled to a job, we can fire you at any time, with or without cause. That can be terrifying. That can be off-putting. They're supposed to be starting with this positive relation with your company and starting off on the right foot. And so there's no need to overemphasize the at-will relationship. It is true, you can put it in there, but there's no need to throw it in the employee's face. Something else to look at the language of the at-will employment agreement is there are several that say that I agree that the at-will employment relationship cannot be amended, modified, or altered in any way. Very, very bright line, very strict test. The National Labor Relations Board, again, is going to find some problems with that because that's actually not true. The at-will employment relationship can be amended if they decide to unionize and collectively bargain and come up with a collective bargaining agreement that gives them rights beyond at-will employment. So what we like to put in there instead is that the at-will employment policy can be modified by the company only by a written agreement signed by the HR manager. So that would be the collective bargaining agreement. So we're not saying that it can't be changed under any circumstances, but that the company is the only one who can change that at-will employment relationship, just to let them know that a manager can't do it by just saying, you are guaranteed some term of employment. So that's at-will employment. The last two slides here deal with child abuse reporting in Georgia, because there are several organizations that work with Pro Bono Partnership of Atlanta that deal that work with at-risk youth and children and who have certain child abuse reporting requirements. That's not my expertise, but I did provide some explanation here about what is required, what to look out for, and if your organization does work with that population, then I would encourage you, when you're working with an attorney on your employee handbook, to make sure that there is a section on child abuse reporting so that your company, your organization and its members know how to appropriately address situations. So that's it. If there are any questions, then definitely don't hesitate to ask. But if not, then thank you for your time, and we look forward to working with you in the future. Perfect. Excellent. Thanks so much for attending.